Good afternoon, SHRM Long Island. It's Chris Valentino from Jackson Lewis. I hope you guys are enjoying the rainy Friday that is March 31st. But spring is on the way, allegedly, and tomorrow will be in April. So all good news. But with the, certainly the change of the calendar comes new and developing areas of labor and employment law. And the one that we are going to spend some time talking about today, which is a topic that we're going to spend probably a lot of time talking about over the next 8 to 9 months, is the New York paid family benefit law. So if anybody was at the SHRM Long Island dinner meeting this past Wednesday, I presented on this topic because I've been getting so many questions about about paid family leave in New York. What does it entail? What do we need to do? Should we be doing things now? So we tackled this for about a half an hour on Wednesday at the dinner meeting, and we are going to kick off our probably next 8 months of education on this, today during the lunch and learn. So we'll get through it at a 30,000-foot standpoint. At the very least, we'll leave you with information on what you need to be doing, right? As we are all aware, and look at those happy people signing away on the paid family leave law in New York. Everybody thinking there in 2016 it was such a good idea. But let's talk a little bit more about April of 2016, almost 2 years ago. Governor Cuomo signed this into law. It is going to be monitored and overseen by the New York State Workers' Comp Board, which was nice enough to issue some new regulations last month, February 22nd. About 40 to 50 pages of regulations that, in my opinion, leave more questions than answers. They are proposed regulations or guidance on the paid family leave. Understand that the comment period, the public comment period on the proposed guidance closes on April 8th, and from there we should get a finalized version of the guidance. Now, the paid family leave law actually goes into effect January 1, 2018. As of that date, employees will be eligible to take paid family leave. But as you could imagine, and certainly as you have read, there is a significant ramp-up time associated with putting this behemoth of a law into place. And we will talk a little bit more about that today. The message really is, on this last day of March, if you haven't thought about this yet, now is the time. We need to get moving. So a little bit about paid leave. What is it and who can get it? Well, let's start with whom. First, it applies to full-time employees, and a full-time employee is somebody who has worked 26 consecutive weeks for an employer. It applies to part-time employees as well, those who have worked 175 days with an employer. Now, part-time is not defined under the guidance issued by the Workers' Comp Board as somebody who works less than 40 hours. Part-time is defined as somebody who's working less than 5 days. So it remains to be seen, at least in my opinion, how the Workers' Comp Board is going to handle somebody who is working 5 days a week, but 4 or 5 hours a day. Is that person full-time, or would that person really be considered part-time? So hopefully when the guidance is finalized, we'll get a little clarity on that. The paid family leave is not a mirror image of the Family and Medical Leave Act, okay? What we need to know is while there is some overlap, there are some differences. And the first one is that there is no minimum hours worked to qualify. The 1250 under FMLA does not apply to the New York paid family leave law. In addition, under the FMLA, as you know, an employee must work 12 months for an employer in order to qualify, that same requirement doesn't apply to paid family leave. It is merely an individual who's worked 26 consecutive weeks as a full-timer or 175 days as a part-timer. And unlike the FMLA, which has a jurisdictional requirement that an employer must have 50 or more employees within a 75-mile radius, the New York paid family leave doesn't have anything similar. All employers are covered, and there is no minimum employee requirement. Okay. Who cannot receive benefits under the law? Anybody who is out on a total disability under workers' comp, i.e. receiving the workers' comp benefits, is not eligible for this type of leave. Same thing with somebody who is receiving short-term disability benefits. Obviously, somebody who's not employed is not eligible, or somebody who is out on an administrative leave from an employer. Any employee who is working part of a day for an employer and receiving compensation for that part of a day also is disqualified on this day-to-day intermittent basis from paid family leave. And finally, and somewhat similarly to the FMLA, if you have related employees who are working for the same employer, they cannot both be taking paid family leave at the same time to care for the same family recipient, right? Who is eligible to receive paid family leave, and what would trigger coverage? Understand this: paid family leave in New York is not related to and does not cover an employee's own serious health condition. Okay, unlike the FMLA, which does provide individuals with time off from work for the employee's serious health condition, that's not what paid family leave does. All right, it provides for leave for your employee who has to care for a family member, and the family member under the guidance is defined as a spouse, a domestic partner, a child, a parent-in-law, a grandparent, or a grandchild. Okay, one of those loved ones, those family members, must establish a serious health condition in order to trigger an employee's right to take paid family leave. And understand, to a large extent, a serious health condition under New York's paid family leave law mirrors the FMLA, with some variances here and there, but for the most part, it's the same. Right. In addition, an employee can take paid family leave under the New York law for bonding purposes with a new child, or in the case of adoption or foster care, to bond with the newly placed child. And similar to the FMLA, this can be used in the first year following birth or placement. And then interesting that New York adopted all of the military reasons for leave under the New York Paid Family Leave Act. So that's going to mirror the FMLA, whether it's military caregiver or military exigency leave. All right. So what's the benefit? The benefit is, as of January 1st, 2018, an employee who qualifies will be eligible for 8 weeks of pay under this law, and the pay is 50% of the employee's salary or 50% of the state average weekly wage, whichever is less. Currently, the wage is $1,296, so it's about $650 a week. If you have an employee who makes more than $1,300 per week, then you're going to be going with the state average weekly wage. Just a little bit about the state average weekly wage. It is determined by New York every 2 years. So hopefully in 2017 we will get a new one, which in all likelihood will be increased over the $1,296 that currently exists. And you can see the progression. The progression ties in nicely to the minimum wage increases that we anticipate coming from New York in January of 2019. Employees will be eligible for 10 weeks of leave at 55% their salary or the state average wage, whichever is less. in January of 2020. We stay at 10 weeks of available leave, but the percentage jumps to 60%. And then finally, in January of 2021, when the law will be in full effect, the total benefit will be 12 weeks of paid family leave at 67% of the employee's salary or the state average weekly wage, whichever is less. I put in an asterisk under weeks available. Just wanted you to know that the availability of time is prorated for part-time employees under the new guidance. So employees who work 2 days per week are not necessarily going to now get 10 weeks or 8 weeks at 2 days a week. It would be prorated for that individual. All right. So in theory, and I presume in practice, once we get more guidance, this benefit will be entirely paid for by the employees. It will be through payroll deductions for all employees across New York State. The employers must use the employee contributions in order to fund the benefit. Key dates here. June 1st, 2017, we expect the state to issue guidelines on this deduction process, also providing us with a maximum employee contribution amount, which will be remitted. And then on July 1st of 2017, which is only 3 short months away, employers across the state will be required to start the deduction process for the paid family leave fund. All right. So let's make sure that we have those dates tickled in our calendars, because if we do not start making the deductions on July 1st of this year, according to the proposed guidelines, penalties will ensue. All right. One interesting aspect which will create administrative nightmares for employers, at least in this practitioner's opinion, is this whole concept of the employee waiver. If you have an employee who you as an employer do not anticipate being full-time or part-time, i.e. working 26 consecutive weeks or 175 days as a part-time individual, the employee can complete a waiver, which basically says, employer, I don't want you to make the deductions from my pay. I don't qualify, and I'm not going to fund paid family leave in New York. All right. The employee must then give the employer the waiver, and the employer must keep that waiver on file. So this is not a blanket, one size fits all. This waiver concept has now created a bit of an administrative burden for people who don't meet these requirements. It gets a little bit more complicated, at least based on my read, when an employee who is not qualifying for paid family leave suddenly becomes qualifying. If there is a change during the calendar year that requires this employee to work a consecutive 26 weeks or will meet the 175-day threshold, an employer must revoke the waiver within 8 weeks of the change. And following that revocation, must start making the deductions from the employee's pay. The guidelines go on to talk about employers failing to follow these waiver protocols and ultimately being held responsible for the entire cost of paid family leave for the employee in question if the waiver should have been revoked but wasn't. So, more fun stuff on this front. As I had indicated earlier, paid family leave is similar but not the same to FMLA. A lot of questions that I've gotten so far, and certainly at the dinner meeting, were about what's the overlap and, where can we cut corners by implementing merely what we're doing now for the FMLA. Here's a sort of a cheat sheet for you to look at the similarities. By the full effect date of paid family leave, January 1st, 2021, both the FMLA and paid family leave will be providing 12 weeks of leave, all right? Both laws provide for job restoration to the same or substantially similar position at the conclusion of the leave. Both laws require an employer to maintain employees' health insurance under the same terms and conditions that were in place prior to the employee taking leave. So if that means that an employee has a contribution towards his or her benefits while the employee is out on paid leave, that contribution must continue, right? Same as FMLA. Notice periods for taking leave for foreseeable and non-foreseeable events are exactly the same as FMLA. For a foreseeable event, it's 30 days advance notice. For non-foreseeable, it is as soon as practicable. Right? Both laws require the completion of certain forms in order to trigger coverage. There are anti-retaliation provisions under both, and from where I sit right now, it certainly appears as if the paid family leave under New York permits intermittent leave. You can use paid family leave on an intermittent basis. Now, if you go through the guidelines, you will see that there is no section dedicated or earmarked for intermittent leave, but when it talks about the payout of benefits, there are sections talking about employees taking paid family leave on a daily basis, which certainly indicates that intermittent leave may be in play. More to come, I presume, after April 8th when the guidance is finalized. Some differences between the two laws. As I alluded to earlier, paid family leave does not require a certain size employer to trigger coverage. Every employer in New York is going to be subject to the paid family leave. In addition, paid family leave covers employees after 26 weeks as compared to 12 months under the FMLA. Also, as mentioned earlier, paid family leave does not cover an employee's own serious health condition. All right, this is only for family members, unlike the FMLA. And finally, paid family leave does not allow employers to require an employee to use accrued but unused paid time off, where FMLA compels employees to use it when the leave is unpaid. That one is a bit of a ice and winter sort of issuance, because we know that if there is pay being issued to an employee while he or she is out on FMLA, for any reason, an employer cannot force the use of accrued unused paid time off. So that fourth bullet on this slide is a little bit of a non-issue. All right, what do we do now? I've provided you with an overview of the law, most important, the dates that we need to remember in order to get compliant with this. But if I'm an employer, what am I thinking now? I'm contacting my carrier who provides me with disability benefits, and I'm asking about compliance with the paid family leave. Your carriers, all carriers who offer disability benefits are required to, also offer, coverage under the paid family leave law. So get on the phone as soon as possible and start the ball rolling with regard to compliance with your carrier. I would also get the ball rolling talking with my payroll company to discuss how are we going to implement the deductions. You don't know what those deductions are yet. That's not coming out until June 1st. But your payroll company needs to be thinking about how this is going to be implemented. And also, you need to start the dialogue on how we're going to handle waiver situations as they come up. All right, so those are two things that I think we should start doing now. From a nuts and bolts HR perspective, we have to start looking at our handbooks, and we got to look at our leave policies. We need to start tailoring those to reflect paid family leave. First, the law requires that you have a written policy on paid family leave if you provide written policies to employees on other forms of leave that you offer. 95% of the employers that at least I work with have handbooks that provide guidance on leaves that are offered to employees that triggers an obligation to have a paid family leave policy, or at least modify your existing leave policies to recognize the availability of paid leave. I get a little bit more concerned when we are talking about our salary continuation policies, because your salary continuation policies are going to get a little muddied as we introduce paid family leave. If you're providing employees with salary continuation while they're out for family leave reasons currently, then there may be a little bit of an obstacle to giving employees paid family leave. Based on my review of these guidelines, the employee would still receive the paid family leave, but if 100% salary continuation is in place, the employee would then be required to remit the paid family leave back to the employer, which ultimately could trigger an employer having to put PTO back into an employee's bank. Very, very similar to FMLA when you have salary continuation and an employee may be receiving short-term disability or workers' comp benefits. So let's look at those policies and let's get them squared away. Understand that there's required notice postings for the workplace on this. We don't have them yet, but this is consistent with the way New York has been handling these in the past. It needs to be in English, or if you have a prominent other language in the workplace, that other prominent language. New York is supposed to be issuing these sample postings shortly. And finally, I think it makes really good sense for HR professionals to close the door to their office and look at your FMLA policies and look at your FMLA forms, and let's figure out what forms that we're going to need in order to implement paid family leave. The state has issued their own forms. Samples are already out there. They're not finalized yet, but what we cannot do is we cannot forget to issue paid family leave when there is a triggering event, or paid family leave forms when there's a triggering event. The guidelines talk about employers failing to provide the necessary forms for employees to complete will ultimately trigger the employee's right to take not only FMLA, but also paid family leave when FMLA expires. If we get all of our forms completed at the outset of a leave, FMLA and paid family leave will run concurrently, thus not giving an employee additional time off for the family reasons. So you should start looking at your forms. As you know, I'm always available for you through the SHRM hotline or in any other way. You can always email me or call me, and I'd be happy to work with you through this process. A lot to talk about. This is only the first step in many. Attend the SHRM breakfast series, attend the SHRM dinner meetings, and certainly dialing in here. We will keep you up to date on everything you need to know about paid family leave. Again, Chris Valentino, thanks for joining me this afternoon. We'll speak to you next month. Bye-bye.